अरे चंदन हलवाई, शादी हो गई तुम्हारी? अच्छा, मेनावती को लेके सौहार्द बनाने जा रहे हो? आओ दक्षिणा दो, लाओ दक्षिणा, लाओ दक्षिणा लाओ।
पंडित जी, दरवाजा बंद कर दीजिए, हमें देरी हो रही है।
अरे छोटे पंडित, यहाँ उकड़ू बैठ के तपस्या हो रही है क्या छोटे पंडित?
अरे बेटी पुष्पा, कहाँ जा रही हो अपने गधे पर बैठकर?
पुष्पा? मैं मुरारी हूँ, पुष्पा नहीं।
जरा मेरा मुखड़ा देखो, बताओ कैसा है मेरा हुलिया?
Hey guys, and welcome back. First of all, I'd just like to start by saying that we are overwhelmed with happiness seeing all the responses on the giveaway videos and your kind words. All of you have made us just so happy, and it makes us feel appreciated for the work we do and the content we put out. Having said that, all the best to everybody who's entered the giveaway. And today's video is going to be on unsoundness of mind and is provided in section 84 of the Indian Penal Code. So let's just jump into the video of the day. Insanity or unsoundness of mind falls under general exceptions under the IPC, and section 6 of the IPC provides that every section, provision or illustration is subject to these general exceptions, which includes unsoundness of mind. So for this we need to start with a reading of section 84 of IPC, which says that the act of a person of unsound mind, that's the heading of the section, and it goes on to say that nothing is an offense which is done by a person who at the time of doing it by reason of unsoundness of mind is incapable of knowing the nature of the act, or that what he is doing is either wrong or contrary to law. Anything that would have been an offense otherwise will not be so because of this section. Any offense, be it murder, be it culpable homicide, be it theft, be it criminal intimidation, anything which would have been an offense had it been done in normal circumstances, it will not be an offense because it is done by a person of unsound mind, provided the prerequisites of section 84 are met. This is what's meant by general exception. So anything which would have been punishable otherwise by law, which would have been an offense, will not be counted as an offense. It will be an exception because it is done by a person of unsound mind. So let's delve a little bit deeper into it and understand the essentials or prerequisites of section 84 in detail. So we understand that section 84 has to be fulfilled before the general exception can be applied. Section 84 provides two essentials. Number one, the accused has to prove that at the time of the act, he suffered from unsoundness of mind. He can prove this by gathering evidence and witnesses before or after the act who will testify, who will show, maybe there is camera footage to show that this person has been acting out of his mind, he did not understand what he is doing. So he will have to gather evidence before the act and after the act to show that he was of unsound mind. So he has to prove that he suffered from medical unsoundness at the time of the act. That's essential. Number two, once he is proven that he indeed does suffer from medical condition causing unsoundness of mind, he further needs to prove, number one, either that he is incapable of knowing the nature of the act, which means that he was incapable of understanding what he was doing, what is the nature of the act, what the act entails. So he has to prove that. He can either prove that or he can prove the other point. The other point means the second point, which says that or he can prove that while doing the act, he did not know that it was morally wrong, plus he did not know that it was contrary to law. So if he proves that he did not know the nature of the act, he was incapable, he did not have the capacity to know the nature of the act. He either proves that, then he only has to prove one thing, his incapacity to know the nature of the act. That's all he needs to prove. But if he proves the second point, if he goes for that one, then he has to prove two things. He has to prove that he did not understand that the act was morally wrong, and he also has to prove that he did not understand that it was contrary to law. One of the leading case laws on this is Ray versus Brixey, where a maidservant slit the master's child's throat and claimed the defense of unsoundness of mind. However, she was unable to prove that she did not know the nature of the act, and she was also unable to prove that at the time she believed that she is not doing anything morally wrong, and she believed that it is not contrary to law. She could not prove either of the defenses provided. She had hidden from the police after slitting the throat, and she had confessed everything to the master, and she was remorseful. She knew that she had done something illegal, immoral. So because of all of this, she was not able to prove that she was of unsound mind at the time of the act. So if anybody is evading arrest or acting remorseful, it shows that they understand the nature of the act, what they have done. They understand it at some point, at some level, and that shows that they are not of unsound mind. Same was held in Dayabhai Chhaganbhai Thakkar versus State of Gujarat, and also in Shrikant Bhosle versus State of Maharashtra. Now, you understand what are the essentials of Section 84, and that both things have to be proven. It has to be proven that the accused suffered from medical unsoundness, and then he has to prove that he either did not know the nature of the act or that he did not believe it to be morally wrong and contrary to law. Now, the burden of proof in this is important because the burden of proof falls on the accused. The burden of proof for proving the case falls under any general exception is on the accused. So the accused has to prove that at the time of the act he was of unsound mind and his case falls under Section 84. This can be gleaned and understood from reading Section 105 of the Indian Evidence Act, read with Section 4 of the Indian Penal Code. Once you read those two, you will understand that the burden of proof is on the accused. There is a rebuttable presumption that the accused was not insane. The court will presume that the accused was not insane. He was in his senses. The burden of proving that he actually was insane and he was of unsound mind will be on the accused. He will have to prove that when he committed the act, he was of unsound mind as per Section 84 of the Indian Penal Code. He may rebut the presumption taken by the court by showing evidence, either oral or documentary or circumstantial. This was held in the case of Bapu, alias Gajraj Singh versus State of Rajasthan. And that brings us to the end of this video. If you have any questions, comments, requests, leave them in the comments down below. And don't forget to hit the subscribe button so you get notified of new videos.